we are going to be talking about something that freaks most of you out today. It is custody evaluations. And so today's guest is Tracy Galloway. She's an attorney in Massachusetts, and I mistakenly thought that she does not do custody evaluations anymore, but she just told me that she does. So she'll get into everything you want to know about custody evaluations so that you're not so scared. Here she is. Let me try to get her on here. Community, because of these, major custody battles where people feel like, I don't want to do well. I don't want to mess up. I don't want them to think that I'm the bad parent. And I've got
That's
piles
okay.
of notebooks and I want to just dump it in the custody evaluator's lap. And so today we're going to clarify some misconceptions. And Tracy, you did a beautiful job as an Instagram live version, just jumping right on with your
Yeah, so
gorgeous
excited.
hair,
Thank
distractingly
you.
gorgeous hair.
Thank you.
So before you even introduced yourself, I said we're going to start like we're talking to people who have never done this before. Hopefully no one has to do it multiple times, but we have some clients who do. Tell us, what exactly is a custody evaluation and
Okay.
when is it recommended?
A custody evaluation is a process that can be requested by either of the two litigants, or it can be initiated by a judge who feels the need for help from either a clinical person on the outside or a legal person on the outside. The two lawyers and the two parties aren't enough because things are either very contested or they're just so murky. They just don't have enough facts. So what the court does, and there's some branches to this, but generally what the court does is a third party, an outsider, is selected, sometimes by the agreement of all parties in counsel, and sometimes off of a list of people who've been certified or educated in some way by the court system, by the state, to be an investigator, to be a fact finder, to be the eyes and the ears of the court. If it's a legal person, that's somebody who is only fact finding. They are fact finding. They are meeting with everybody and documenting what everybody says and what paperwork says. Sometimes in Massachusetts, we have category F GALs, who are people like me, lawyers, and we also have category E GALs, who are clinicians. And those people are often considered more desirable because they have more ability to diagnose, more ability to deal in a professionally licensed, qualified way with things like substance abuse or mental health issues. So we have both kinds, but the point is that these are people who are independent. They don't work for anybody. They work for themselves.
Okay, again, one tiny question since you just said
Sure.
that before you introduce yourself. There seems to be a belief that if one person in the couple is paying for the GAL is biased. Is that true?
Absolutely not supposed to be the case. And frankly, here in Massachusetts, we have guardian ad litem standards that have to be followed. So it's really important that you know when you are a divorce party, it's very important that you find out what kind of GAL you have, what their role is, because there are lots of ways in which the roles of even a neutral professional can sort of be sculpted. And there are standards from a variety of sources that you can go and look at and see what is it this person is supposed to be doing. For example, some GALs, this is a separate issue, this is not a custody evaluation, but a custody evaluator might need to talk to a child therapist. In Massachusetts, in order to do that, there needs to be another little mini GAL whose job it is to evaluate whether or not that child would want their privilege with their therapist to be waived. And that's called substituted judgment. That's when a grown adult person like myself is supposed to investigate, talk to everybody, and figure out what would that child want. And I've done that before, and sometimes I'll find that a child needs that protection, and I'll protect or assert the privilege. And sometimes I find that a child not only doesn't care, but wants both parents to know what they're talking about in therapy, in which case I would waive it. So I have a different hat on of substituted judgment sometimes versus when I'm doing a custody evaluation and I'm being asked what I, Tracy Galloway, thinks, what my professional opinion is as to what's best for the children. So it's really important that you find out, and you can find out even through court personnel, what kind of GAL we're talking about when you're talking about these, because they're not all the same.
Oh, okay. This is awesome already. Now introduce yourself, Tracy. Who are you? And tell us a little bit about your background.
I am attorney Tracy Galloway. I've been a Massachusetts child custody and divorce attorney for over 30 years. We'll leave it at that. I started out with the Department of Children and Families, so my roots were in the litigation involved in child welfare cases, abuse and neglect cases. And then I transitioned into private practice, which I've been in one form or the other since 1998. I'm honing my practice down a little bit to just divorce. I don't do all family law cases. Sometimes I'll do a restraining order because that's related to a divorce. And for clients that I've gotten divorced, I'll do a little post-divorce work when they need it. But mostly I'm just all about the divorce factory because it's a very it's its own model, and it ends up with the happy result at the end of a divorce. So I need the happiness for my clients too.
Yes, sooner
Um,
rather than later,
yeah, yes. So
if
that's who I
possible.
am. I've also started an online divorce coaching business called the Divorce Bootcamp that has its own website. And I'll talk a little bit more about that later, but it's basically born out of the frustration that there isn't more information available in a variety of ways, including video, which is some people need to learn from video. They can't just read a website. I don't know about you, but I learn better and faster if I have
Me
multiple
too.
ways of,
Visual.
yeah,
I'm like
visual and
someone just
auditory. I need it
tell
all.
me what to do. Just tell me
Yeah,
what.
just tell me and tell me what I need to know about what the process is really like. So I'm creating free and low cost resources and being available as a coach and just feeling my way through it. I started this literally 1 year ago, and it's only in the last few months that I have an up and running website, and we'll see where that goes too. But
Yeah, well,
anyhow.
I so appreciate that we're giving out this free content today on this really, really important issue. So another thing, you know that all of our clients, mine and Chris's clients, are the most extreme cases, all of them involving some type of domestic violence. And often we see our clients go into a custody evaluation and they want to talk about their experience with domestic violence to a custody evaluator. Tell me what you think about that.
Well, here's the thing. It's not the what, it's the how you talk about it that is critically important. The facts are the facts, and if you have some professional guidance, it can be a lawyer, but actually at this point in time, like, I'm all about you guys, because
Thank you.
I love this book. She didn't ask me to do this. I'm just telling you, Lisa and Chris are the best informed lay people I've met.
Oh
So
my, thank you
you
so much.
need, so going to a coach is a less expensive way of figuring out how to present in a way that is credible and proportionate. It doesn't mean that your feelings don't matter. It just means that there are times and places to do the heavy emotional lifting, the heavy processing, the deep weeping. It's
Hmm.
not with it. It doesn't mean you can't cry. It's just that an investigator's job, when I'm a GAL, I need to see that the person in front of me is being proportionate about their experience, but also able to hold in their mind at the same time that a judge needs facts and what's going to be best for a child. That's a lot of plates to hold at the same time. But
Mhm.
if you can do that work, if you can balance, sort of, not compartmentalizing, but just sizing the pools of information so that you can communicate effectively, you will be enhancing your credibility with a guardian ad litem investigator, and you want them to believe you. You want them to like you. They can still report the facts. I can still report the facts when I don't know whether or not somebody is lying to me or telling me the truth. I can still report what they're telling me. But sooner or later, in an evaluation and in a court process, being the most credible person is what gets you the most with a judge. So training that part of how does one communicate? What does one communicate? In what form? Is it going to be verbal or is it going to be written? Those are all discretionary questions that somebody like you would be in a better position, because you're going to have the ability to get to know somebody in it with over greater time at a lower price than any attorney is.
Yeah, thank you so much for that, Tracy. Okay, so you of course made me think of something. Doesn't matter who meets the GAL first. We hear about confirmation bias. So if I meet you first as the mother, are you going to believe me more? And then my partner, you're going to believe less because now they have to kind of overturn my story. Does it matter to you?
It does not matter to me, but I'm a pretty well disciplined practitioner. Like, I know going into the meeting with the first person that that's involved. And the more educated and the more your guardian ad litem has been around, in some ways that's better. In some ways people can get a little burned out or assume that they're on top of things that they're not on top of. But let me tell you what I tell my clients. I don't need them worrying about that. There's so much else to worry about. If
Mm.
I think that a GAL is torquing a particular way, let me handle that part as an attorney. For a litigant, I think it just makes them anxious. If they've
Hmm.
got their ducks in a row, if they've got police reports, if they need police reports, if they have affidavits from people that they want the GAL to talk to, if they've done their homework, they don't need to worry about that. That's not something they can control. So I don't
Hmm.
think that it ever pays to worry about something that you can't control. I
Yeah.
think it's
Yeah.
smart to think about it and to think whether or not you can influence the situation, but if you can't, let it go. It's a distraction. That's just
Yeah.
my take on this.
Yeah, and I mean it makes sense. I've heard that the person who communicates more quickly and pays on time is a little more likable as well, rather than having to chase after that.
Absolutely. You don't want to put a GA if you can't afford this or you don't know how you're going to pay for something, you need to take responsibility for that. I've had cases where people, because think about it, if I'm a GAL, then I have a choice. I'm either billing or not billing for the time spent chasing you. What a waste of my time. Why
Mm.
irritate me? Do you know what I'm saying?
Yeah,
So
yeah,
either have the plan or surface to everybody. I can't do this right now, but in 30 days, I should have. Can everybody agree that we're going to delay this for 30 days? I'll be getting my tax refund and I mean, people are so much better when you surface problems proactively than when you just drag it out and clam up. That's my take on it. So I always appreciate honest communication and transparency about what the process is going to be, because then I don't need to think about it. I can calendar it, forget it, go about my business, and then I find it on my calendar. Oh, let me circle back and see if they're ready. It's
yeah.
fine.
I mean, both you and I agree how important it is to communicate. And I think with clients who are also very needy and freaking out, just to have communication, everybody calms down a little because they know a little bit more of what to expect. So speaking of that, let's say I am going into a custody evaluation for the first time. You mentioned ducks in a row. So what are some things that I should bring? And I'm guessing you're not going to say stacks of binders.
No, you consolidate that. You go through that. I love in your book, you say, have your 3 to 5 most pressing issues. Don't use conclusory language. Well, I was abused. I want to know when. I want to know how. I want to know exactly what happened. Those are the details. So have the ability to communicate that information verbally. You can have legal pads, you can have pens, you can have bulleted points. I don't ever take issue with somebody who's prepared and who wants to check and make sure that they've talked about what they want to talk about. They're not reading it. They're looking at it and going, oh yeah, I forgot. I needed to mention what happened at the school 2 months ago. I know that that's a little while ago, but still, it really upset my child. And I think it's important that you know about it. So you can refresh your memory a little bit. It's kind of good practice for testimony. That happens in a courtroom too, if anybody's ever going to testify, which I
Yeah.
know that that's down the road, but still, it's good to take charge of how you need to communicate your narrative to an investigator.
Yeah, and when you said conclusory language or evidence, so that I think when we talk to our clients, we say you want to let the evaluator draw their own conclusion. So don't come
Yes.
in and say, this is what happened and why. This is how my kid feels. Describe it like you're a journalist. Like, this is what they did. This is what happened. This is what maybe apparently it seemed to be, but it's insulting, right, to a
Yes.
professional to say, I already have the answers and I'm just going to tell you what
Well,
you
you
need
know
to
what
do.
else it is? It's a little narcissistic. And I say that, I know that's a trigger word, but when you think that what you're saying is obvious, as opposed to taking the time and effort to be understood, I mean, it's like any negotiation or any communication. You want to make sure that the person you're talking to is hearing you. It's not about you saying it, it's about what's landing for them. It takes work. That's why I focus on this as homework. I really believe that any divorce process, any custody evaluation is it's it's layered with the development of ourselves as individuals and our ability to communicate with anybody about our situation. So it behooves us to use old-fashioned language, but it behooves us to prepare, to rehearse. You might want to even take time alone in your home or your car, hearing how you sound when you describe something. I recognize that's asking a lot, but it's so effective. So that's what I mean.
Yeah, I mean, and we've talked about how obviously Chris and I are not attorneys, so we can't give legal advice, but what we teach is the art of persuasion. And I always think about three different elements, not just to a judge, but let's say to a custody evaluator. The first is logos, which is like your actual evidence and your facts. But
Yep.
people often believe that the facts speak for themselves. And like you said, you got to put it together. It's not like
Yes.
here's everything, you figure it out. And the second we talk about is pathos, so your presentation. And that's where most everything comes into, because if you are absolutely hysterical, it doesn't matter if your facts are great because people have stopped listening, right? And you just said you want to make sure the person is hearing what you have to say. And
Yes.
then for us, the third is ethos, which is basically the decorum or the etiquette of wherever you are, to understand where you are in the power dynamic. I often think about the courtroom as like the judge is the wizard and you're Dorothy. So you cannot
Yes.
come in there like telling them what they need to think or what they need to do. So all of those together also apply to speaking with a custody evaluator. You got to know your place. You got to know that they do have a lot of power. So like you said, making yourself as likable is going to make you more believable, not coming in with like a big data dump and saying, can't you see? Who does
Yes.
this? And then leaving.
Yes. And I'm gonna add to that and just say on the other end of the spectrum, instead of just it's obvious, it's a distraction if you're overly apologetic or just I don't know, oh, I'm so sorry, or I understand it's emotional. Like I shouldn't be doing this work if I can't give room for somebody to be having some amount of feeling. But apologizing for not being able to communicate information isn't helping you. I'm fine. Here I am. I'm getting paid. I'm taking down the information. I'm making my observations. I,
Mm-hmm.
I, I take, I take very detailed notes. I write a lot. I notice a lot because I really believe in a picture paints a thousand words paints a picture paints a thousand words.
Yeah,
And so I want to paint with my words what I'm seeing. I'll describe a home environment. Are there throw pillows? Like, are they clean? I'll be taking in a lot.
mm-hmm.
So relaxing a little bit and counting on me to see what you are presenting to me is also a good piece of advice in terms of helping people to relax. You don't need to do as much as you think you do. You need to
So
have
my
your
house
facts.
doesn't need to be perfect when you come for a
Never.
visit.
I like a house to live in. If it looks too clean and too tidy, somebody's been working hard to fake a presentation,
Mm,
right?
yeah.
That's one other thing I wanted to say, because it was one thing, and I get why it's there professionally across the field, but uh, I'm going to just talk about your book for a moment.
Okay.
You say that it's critical to always present as being puzzled by the other person's behavior. And I have this issue with the BIF method as well: brief, informative, friendly, factual.
Mm-hmm.
I'm not a fan of any kind of faking. I think it's apparent. I think it's more apparent than anybody recognizes. I don't want people who are in a highly contested situation to pretend to be friendly. It's fake. It doesn't contribute to credibility. So what I try to explain to my clients is that we have a pH scale. We have chemicals, right? We have very acidic on one side, very base or alkaline on the other. You want neutral. You want water. So instead of being puzzled, just notice a behavior. I don't want my parent clients to be injecting, as you said, the judgment for the GA. Let the GAL see what the behavior did. Let them see it. You just paint a picture, be neutral. They'll see it, or they'll report it and a judge will see it, especially
Mm.
when you can show a pattern. So just have confidence in that. Don't feel the need to press or sway. I agree with you about thinking about influence, but the true influence is from the person who is holding their own center of gravity steadily. That's the real confidence inspiring work that can be done.
Ooh, I love that.
Let
Holding
me
their
thank you
own
for
center
letting
of
me
gravity.
go on my tangent. I just wanted to share that with you as one professional to another.
Yeah, that's really helpful, especially what you also said about being overly apologetic. That's something we see all the time. Is
Yes.
our clients are apologizing all constantly. It's a carryover from the relationship and feeling
Yes,
like
it
they weren't
is.
good enough. So, but
But
that
it's
is
time to
something to
start
work.
working on yourself. You are good enough. You get to participate in this process. I know we also have to participate, but it's an opportunity to move the ball forward constructively and to be helpful to a judge. And if you can wear the jacket of, I'm trying to help make sure that the facts of the history are being delivered to the judge in a compact way where they can be in their jeans and t-shirt in the lobby or at home on a weekend reading it. They don't have to be exhausted by being in the courtroom because it's hard on them too. I mean, it might not look like it or you might not think about it, but they are people too, right? Just like the wizard was just a person, right?
Yeah.
They put on a robe and they've got the lights and the and the security personnel, but they're people too. So you want to make it as easy for them to see who you are as possible.
Yeah, yeah. And it does take a lot of work in terms of presenting properly and trying to stay, not that you, like you said, not that you should have no emotion, but realizing when to use it and when to not make it too much about yourself. Um,
Yes.
the other thing is, so you mentioned about being overly apologetic, and that's a bit of a turnoff. Are there other mistakes that you see made often that you can warn people about, like this is something don't do, or misconceptions people have about this whole process?
We could talk all day about each of those. You just bundled two big questions there.
Okay, give me like two questions because I can think of a couple.
Um, well, misconceptions. Um, first of all, lawyers will tell, and I will tell my clients, lawyers will tell their clients that pretty much what the GAL decides is going to happen. And that's not 100% true because there's still a process, right? So this feeling that it's make or break, again, it puts too much pressure on the
Mm.
moment. No human can be perfect under that weight. Yes, it's important and it is worth preparing for, just like anything, but it is not the end all be all. The person who's the end all be all is the judge. And by the time a case is either at a pretrial conference or going to trial, there's more than just the GAL's report. So again, I only offer that in the spirit of it doesn't help to think about anything in this world and in this process as black and white. So that would be one misconception. Because I've had GAL reports that judges have. First of all, the question of whether or not a judge should even read a GAL report before trial is a contested issue, at least in Massachusetts. That's the equivalent of taking evidence before a trial. They're not supposed to
Ooh,
do that.
interesting.
Some judges do, though, and again, I'm not going to comment on individuals, but they do because they want to know which way a case is leaning before a pretrial conference so they can be more helpful and give feedback on, especially if it's a clear situation. So, and again, I've argued it both ways depending on the needs of my client at one time, all ethical, of course, but so that's a problem. That's an issue. I've had judges completely go against what a guardian, even a great GAL has recommended. I've had judges do the opposite or do something very different. So again, I don't want too much pressure on that. I can't remember what the first part of your question was because I thought of an answer to the second part.
Oh, that's okay. I would said like myths, misconceptions, and this is a big
Misconceptions and what
topic.
should they do? Or yeah, again, just preparation, just homework. And whatever that means for you, distilling, having your own pad, your own notes, what you want to refer to, what you want to talk about, and then waiting and seeing what a GAL wants to ask you about. And here's the advantage to going second in terms of the parent interviews. They're going to have heard things from the first parent.
Mhm.
I consider that sort of free discovery. I want my client to
Mm.
be able to field those questions. Like, I understand you may have had a third party here and introduced them to your child. I want that question. I hope that clients have talked to their attorneys about any mistakes they've made or anything that they've done that a judge might not want them to have done, because taking responsibility for that is really important. If you've made a mistake during the process, own it. Don't hide it. Own it. You look
Yeah.
more credible when you say, yeah, when this first happened, I was very upset or blah, blah. And then this is the way I behaved. I've stopped doing that. Here's what I'm doing now.
Yeah.
That's great. Growth is
I'm so
great.
glad you said that because we talk about that a lot where people might have had problems in the past with addiction, mental illness, and anxiety medication is a big one. Like, oh no, my ex is going to tell the jail and they're going to think that I'm unstable or an unfit parent. And we try to calm our clients down and say, if you have been working on yourself, the fact that you can show progress of like, I acknowledge this issue, I'm taking accountability, and look at what I've done to try to work on it, that makes you look better than somebody who maybe
Absolutely.
had nothing.
Well, and not only I had a case once, and this client has given me permission to talk about this anytime it might be helpful to somebody. And it was a female. It represented a mother who'd lost custody at a time when she'd had a mental health crisis. She'd had a breakdown that was prompted by a physical injury. Her ex-husband used to come into court. We used to, with a silver Samsonite full. He brought it to make her think he was carrying all of her psych hospitalization records. And I was like, we want to see that suitcase. He is saying more to the judge by bringing the Samsonite into the courtroom. He's saying more to hurt himself. You have nothing to worry about. And she got braver and braver, and she ended up winning the case, and still wins and still wins. So
That's
don't be
great.
afraid. Own it. I call it the show your upper body method. Just show it. Show it. It won't hurt you to show it. If you can own it, if you can say, yes, this is what happened and this is why, and here I am now, and here are the steps I'm taking. You've just disarmed them and made yourself look like a believable and trustable parent to children.
Yes, yes, love it. It's making me think of the term of making a concession in the art of persuasion, where you anticipate what the other side's going to say, and then you blend it into what you're saying so it takes the wind out of their sails.
Another reason to want to be the second parent interviewed.
Mm, very
We're
good.
choosing to be second, not just oh how we make up for the fact that we're second. Choose to be the second one, because if you can come in there and do that when they've spent time expressing their concerns about you, and you can say, yeah, no, I know he or she is concerned about me, I know that. Here's how I look at that. Oh God, mwah, that's fabulous.
Chef's kiss.
Chef's kiss.
Awesome. Okay, what about this one? A lot of people think the voice of the child matters more than anything else.
It depends on so much. Depends on age and credibility and the character of the child. This gets into the different roles of things like, for example, you can have a guardian ad litem whose job is to recommend what's best for the child. But in Massachusetts, you can also have, in different kinds of cases, you either have there's a reason why I'm taking you out here. We're going to go back to your question, but you can have ARC attorneys representing children, who are only supposed to say what a child says they want. They muddy that.
Mm-hmm.
I've muddied that too. Or you also have children who are appointed in certain kinds of cases, who are paid by the state because it's a constitutional issue. And we have performance standards when we are certified to do that kind of work, where yes, we report what a child would say, but we also might report what we think is the best interest of the child. So we have a hybrid role. So all of those roles matter. When I represent a child, I always tell a judge what the child would say. And if it's appropriate to my role, I might also point out where I'm concerned about that. You know, teenagers are supposed to be living a life where their sports and their friends and their activities begin to trump even, sorry about that, begin to take over their time with either parent. So it might make sense, depending on the maturity of any child, but a GAL can't just assume that. And that's in my experience, that's not something that should be a hard and fast rule, because there are cases where either intentionally or unintentionally, one parent might be influencing a child more, or a child's character might be more fearful on behalf of one parent or the other, or on behalf of their own sake. You know, we are wired, as our children are wired, to make sure that they survive growing up and not inspiring anger in either parent. So how strong a child is in being able to speak up for themselves. I've had cases where children simply can't do it. They're literally unable to tell an investigator what actually happened. They're just too
Mhm.
afraid that that a parent is going to get in trouble. They can't. They just can't do it. And so I don't like to have a hard and fast rule on any case, is the answer to your question.
Yeah, yeah. I'm so glad you said that, because when you briefly touched on how kids can be influenced, I mean, that's the topic of, and I just got the cover of the next book, When Your Ex Turns the Kids Against You, because this is also super common in our community, especially as they become teenagers, where for whatever happened, a child has aligned with one parent. And
Yes.
sometimes the reason is because that parent doesn't have any rules, that parent allows them to do a lot more.
Disney parent.
Yeah, or like or just they've been convinced to show their loyalty to that one parent, and then a GAL gets involved, or you said ARC, we call it an AFC, attorney for the child, who's supposed to represent what the child wants. And it's been tricky for our clients whose kids have been alienated, because they're like, my kid is saying they don't want to be with me at all. They don't want anything to do with me, and they're 14. And so the court's just going to listen to that. But I feel like it's not always a given when you have professionals involved who understand that kind of dynamic. How do you
It's
deal with cases like that, where you can sense that the child doesn't have a really good justification, but they're like, I don't want to live with that parent. I want nothing to do with them
this is
during
this is a
divorce.
this is a really tough area, and I'm going to answer it in two ways. And I'm a little unconventional, and I'm so just warning, don't just listen to me, go consult
That's
with your own
okay.
attorneys,
That's
because
okay.
I don't. So as a guardian ad litem, it's my job, again, to report. I report what's happening. I report what each side says is at work, and I'm very clear. It, sometimes parents influence their children on purpose, and sometimes they don't even know they're doing it. And
Mm-hmm.
sometimes it's a mix, right? When parents tell me that their child feels in a certain way, which is not, that's not admissible evidence, I will say, how do you know that? What does that look like? Tell me what you see when you see your child being under the influence. Tell me what that looks like.
Mm-hmm.
And I'll report what they say. Well, they spend their time, or when the phone rings, they jump because they're afraid it's the other parent. So I will document for a judge, but I don't want the robe. Like, that's a tough job.
Mm-hmm.
As an attorney, if the other parent has been successful at controlling the children, or control, let's just talk about one child. It's enough. It's too painful when it's more than one.
Mm-hmm.
Um, I haven't seen a fight that succeeded. I've
What do
been
you
in
mean, a fight that succeeded?
a fight to reclaim a child who has become enmeshed with a parent,
Mm-hmm.
or is so afraid of displeasing that parent that they won't pull away.
Mm-hmm.
I haven't seen a grab back of that child that has succeeded. And I think a lot of time and money could be spent in certain cases trying and failing, which is even more of a heartbreak.
Mm-hmm.
So I will often be in the position with my clients of at least vetting the idea, of at least talking about, well, what would it look like if you dropped the ball? What if I shouldn't say that language, if you dropped the hot potato, if you stopped fighting for a while, so that it's not a constant, they're pulling like a tug of war, and they're getting further away from you. What if you stopped right now and took some time off and healed a little bit? You're going to cry a lot, you're going to miss your child, but what if then you came back in a year, or you texted them, or you mailed a birthday gift, but the other parent feels that you're no threat? Like, I just want to see a dynamic that's changed, rather than what my experience tells me is a losing battle.
Mm-hmm.
And again, I'm just an advisor. If a client says to me, I can't, it's my child. Okay, what shall we do? What shall team client do? What do you want us to try? But I have had clients who've come to me afterwards, who have let go, who've stopped being controlled. Because again, when you care that much and you're trying, the other parent knows that they are winning. It's just a terrible dynamic. Anyhow, I have had clients come to me and say, you're right. I finally let go. I went on about my life, and then something happened and now I get to talk to them and I get to see them and it's better now. But it's terrifying because it takes a long time. We're talking, this doesn't just change in weeks or months. We're talking sometimes years, and that's excruciating for parents. And I understand that.
Yeah, yeah, and it is really hard. And so, we know certain colleagues in common in Massachusetts who deal with cases like these, who also say there's the legal end and then there's the mental health stuff. So
Yeah.
what's really the goal? And a lot of times when a child has had that happen, teenager, whatever, the goal isn't just to get your legal rights, it's to repair the relationship first.
Yes.
So, but
Yes.
we'll see. You got to
Right.
see case by case.
Right. And if the other parent, well, the child doesn't need therapy, like it's just such a mean-spirited environment.
Hmm.
And you
Yeah.
can't, and remember, by the time a child is a teenager, they have their own, whatever it is that's going on for them, their character and their own personality, and what is easier or harder for them based on homework and what's going on for them socially. Like sometimes it's not actually about the parents. It's just life is hard enough getting through a day, and,
Mhm.
they're trying to make the basketball team and it's not going well. Or what, they're supposed to be involved with their own lives too. They're not supposed to be thinking first about the parent who's not getting enough time with them. That's why I that's why I find it a little bit crazy when parents fight for, their birthday with a child. Children are supposed to be children. They're not supposed to be taking care of their parents' feelings all the
Yeah.
time.
Yeah.
Sometimes, of course, you want to raise a child who's aware and who cares, but they're not in this to make their parents feel better about being parents. And so it's hard. This is all very hard stuff. And I'm making it sound like it's cut and dried because I talk fast, but it's not. It's very complicated.
Yeah. 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 We know. So let's say that a GAL report comes out in court and a parent gets really angry, which I'm sure you see all the time, and say, I don't agree with that. The GAL got all this stuff wrong. What recourse does someone have if they completely disagree with the GAL?
Well, it depends on whether or not they disagree with, in other words, if there are errors, if a client says to a GAL, I pack lunch for my child, and the GAL recorded, I don't pack lunch for my child.
Mm-hmm.
And, the child has diabetes. Like if there are mistakes in the facts, you can record that. You can make a record of the factual disagreement. You can share that with the other side. You can share that with the GAL. You can ask that this be revised.
Mm-hmm.
If, which happens more often, they didn't get most facts wrong. They just came to a conclusion that somebody doesn't agree with. Getting angry isn't going to give you any more credibility than the GAL. You have to
Mm-hmm.
decide at that point in time whether or not you're continuing with litigation or settling. And that's an evaluation of the report, how the report was done. That's when looking at the standards, going through the report and picking out the errors or picking out what you disagree with, and then presenting it to your attorney, if you have an attorney, or making it into an affidavit if you're not represented by an attorney, is important for the record. The calculation of whether or not you settle a case or go to trial, case by case basis.
Yeah. All right. Now I'm going to throw you a couple of interesting little curveballs from
Yay.
client situations. Okay.
Great.
Number one, parents have shared legal decision making on religion. Both parents are different religions, and one parent, and this is before a custody evaluation, goes and gets the child baptized. What can somebody do about that, if anything?
Well, the baptism has happened. So for
Yeah,
that
it's over.
parent,
Yep, they've
yeah.
already been. Yeah,
So if it's decision making around
it's
religion,
yeah
and
decision making.
somebody has taken an action without informing the other parent, you have a possible contempt action. You have that somebody didn't follow a court, or I'm assuming the agreement was incorporated into an order of the court or a judgment. You have a possible contempt action. And that person's also shot themselves in the foot because they've shown that they will take action that violates court orders.
Mhm.
How you present that as a contempt to the court is one where I encourage my clients to think of it as exposing what we assume will be a pattern. In other words, most judges are not punishing, right? They don't
Yeah, yeah.
punish, right? We
No,
want them to. We
I
want
know.
law and
We
order.
really do.
We want to be vindicated,
Yeah.
right? Nope. Because and the science does back this up. Kids need both parents. However flawed, however awful, however malicious a parent is, they're presumed better alive than dead for the sake of a
Mhm.
child developing and needing more resources, needing their whole village. That includes bad actors in a village.
Mhm.
So being infuriated, I help my clients to join a kickboxing class because it won't help you in court. Judges aren't going to take up your mantle of righteousness and impose the sanction. It's not going to happen. But if you bring it to a judge's attention and say, "Judge, this is what's happened. This is reflective of my co-parents' refusal to abide by court orders and to work with me," and you want to ask for a different order, you come in with a draft order that says something different. Neither party may,
Mhm.
subject to sanctions. Or you say they may only, you might need to come up with a different. I've had cases where they each have different religions and they're each allowed to participate in the functions of their religion during their parenting time with the kids. Like,
Mhm.
child's being raised with two religions, which is contrary to both religions, but sometimes that's the only thing that you can control is the behavior, right?
Yeah.
So I would work with a client on that, and I would want to memorialize it because that's a big one. On religion is a big one. If it were, we don't believe in wearing blah blah blah. You have to weigh it whether or not you're going to ask for the court's attention. But that's a big one. So I'd advise at least a complaint for contempt on that to say this is what happened. They're not disputing they did it. I need that person found in contempt. Now I will say that recently in this last year, I have brought the clearest contempts of my life to judges, and they still won't find somebody in contempt. I don't know how to explain it. Makes me feel pretty pointless as an attorney, and I try to help my clients to sort of roll with that. But you still have to point out when somebody is just flagrantly violating court orders.
Yeah, with my own case, my ex was found in contempt 5 times, and it was just a piece of paper. So it's
Right.
really in terms of asking for specific relief that kind of connects the dots. And when someone's been baptized, what are you going to say? You're not allowed to make a decision on religious stuff, which it's already happened. So
Yeah, it's
what can you
over. They're
really ask?
baptized.
Right.
Yeah.
It's done. It's
And
done.
they won't. I have had judges order on when they've gotten irritated with somebody, and this does not happen very often. But a few years ago, I had a judge order somebody who brought a frivolous complaint for contempt against my former client. I'd gotten the parties divorced. 7 years later, she wanted personal property. It was ridiculous.
Hmm.
The client spent, I don't know, $2,000 on me trying to help her to get her some stuff that she had no claim to anymore. But he tried to be helpful. He used me nonetheless, and she would not give up on wanting to call him out to the judge. Well, the judge got irritated, and the judge found that there was no contempt by my client, but only ordered her to pay me $500. So my client was
Hmm.
still out $1,500. So
Yeah.
the question, right? Are we going to do this or are we not going to do this?
Right.
And it's frustrating for me too. I don't
I know.
like having a client that I help and then we go and judges don't do what I think they ought to do. Order
Right.
and with your ex, the first contempt, okay, maybe we don't punish, but you have to start making it pinch where the money is, or people won't change their behavior. If you
That's what
don't
works.
order, right, even $1,000 on a bill, like you have to start escalating. If you don't hit the pocketbook, it doesn't work. And I don't
Yeah.
know why judges don't do it. I don't understand it.
Yeah, yeah, that's a whole other
Yeah,
long venting
subject.
session. Yeah.
Yep.
Okay, here's another one for you. So, couple lives in different states. The child's name has been an issue. The child has several first names and a last name of the mother. Um, this was litigated in family court. The father wanted to change the name. The name wasn't changed. The
To
father is
change the,
trying
the last name
the last
or
name,
okay.
the last name.
Yep.
Yeah,
Yep.
and he calls the daughter one of the different names, but that's okay because there's several names. So anyway,
How old is the daughter?
7.
Yeah. All right, go
Okay,
ahead.
so she knows her identity.
Yep.
So mother has final say on, let's say, medical, and father has changed the child's name when the daughter is with him to make it impossible for the mom to get records because she doesn't have custody of this child with the different last name. So when the daughter had to go to the hospital for something, the father, and they live in different parts of the country, the father gave the wrong name. He gave his own last name to all of the doctors. So our person who has final say on medical couldn't get any information because she doesn't have custody of this other named child. Have you ever heard of something like this?
No, that's fabulous. I have had cases where the name of the child is a live issue. I just had a trial where the mother calls the child one thing and the father calls the child another thing. I would be looking for, if I were the mother's attorney, I would file a motion in mother's home state, or open a new case, a complaint for modification, in which I was seeking an order, not an allowed motion. I would draft an order for the judge to sign saying that child with this name is also child with this name, is also child with this name, any variations of them, and mother shall have the right to have access to all records and to submit forms with this court order to make sure that the doctor's offices know that this particular child, no matter which name, is this child. You might now. I think a doctor's office would be that would be good enough. Yeah. A doctor's office in another state has the right to say that's a court order from state A. We're in state B. In which case, you might need to go to a probate and family court or the equivalent of it in state B and get a full faith and credit action going, meaning asking a court there to take the order from Massachusetts or Connecticut and turn it into their own order to order the doctor in that state. So it's a lot of work, but go for it.
Yeah. I mean, in my head, and I'm not an attorney, but I think enforcement of a foreign judgment, maybe?
Yes.
I don't know.
Foreign decree. Yes.
Yeah. Okay.
Correct.
All right. So now I'm going to come away back because I know Tracy, you're kind of valuable and I don't want to keep you here all day, even though I kind of do.
I kind of would love to be here talking with you.
So for our audience who is going through a custody evaluation for the first time and they're really scared, what are like maybe 2 things they can focus on today to sort of prepare themselves for this thing that's coming up?
Are they pro se or do they have lawyers?
Ooh, good question. Let's say they are pro se, just to make it harder.
Yeah. I would send a brief, informative, factual email to the GAL and say, please let me know if there's anything that you would like from me in advance and anything I can do to make this visit as productive as possible.
Love it. I didn't know I was doing the right thing. That's what we've been telling people to do. Okay, great.
Great. Look at that. We didn't even know that each other does. Yeah, that's what I would do. Be proactive on that. Make sure they have your email, your cell phone, if they need to text you, if they have any questions, and then don't harp on it, but you've done a good job. You've made yourself available.
Great.
I think that attitude of openness is very helpful. What else?
Yeah. Fantastic. Okay. And then lastly, someone in the throes of this kind of situation, high conflict custody battle, feels that rage and sense of injustice and despair, like it's never going to end. You've been doing this for decades. Any advice to give them a little bit of hope that it's not going to stay like this forever?
Yes. Work out hard and get into nature. If you don't get perspective and deal with the energy in your body, you're not going to have a prayer of communicating the way that you need to and want to get your points across. As I say to my clients, I love you, really I do, or I wouldn't work with you. But this is your responsibility, your problem. Go take care of it, and then bring a better person back to me into this process. That's a real problem. Anger management, and we all have it. Look, people like to think I'm psycho or a bully as an attorney. I have a lot of energy. I'm passionate. I care about what I do. And it's true. If I have a face or my energy is loud in a courtroom, it's my job to keep working, and I do decade after decade, on bringing it down a little bit, right? That's my responsibility. So yes, I understand anger. There are lots of reasons for anger, but you met that person, you made a baby with that person. This is what you have to work with. You don't get to say, none of us knew That's the art project of our life. That's what we have to work with. And that person is growing up on their own. Your child doesn't belong to you. So you have to get yourself under control in order to be an effective facilitator for a child's life. That's what I say. I'm pretty hard
Amazing.
line on that.
Excellent. Excellent. And I love your energy, and I'm also very passionate and talk fast and kind of loud sometimes. So
Yeah.
Tracy, how can people find you?
Well, I am both at tracygalloway.com. Thank you for asking. I'm also just shy of the followers I need on TikTok. I'm at 970 today. I would love it if people would come to Divorce.Bootcamp on TikTok and follow me, because once I can go live there, I'm happy to have these conversations as often as people want them. I'm also on YouTube and Instagram, Divorce.Bootcamp, and I have the divorcebootcamp.com, where my free and low cost resources are. And if anybody wants to reach out because they have a question, text me. I will answer. I give 5 minutes to anybody who wants it and don't charge for it. If you're in Massachusetts, that might create an attorney-client relationship. But if you're somewhere else, I'm not licensed in your state. It doesn't necessarily mean a hill of beans. But if you like the way I talk and you want a dose of some fresh talk, text me. My phone number is 508-631-5702. I won't text you back if you're spam or a robot. But any friend of Lisa's is a friend of mine, and Chris's. These guys are great. Go to them first. If you need an attorney, I'm here to help. But this is gold. This is gold,
Oh my
people.
God.
It
Thank you
is.
so much. Thank
And
you.
I'm here for you too. If you guys ever need anything, I'm here for you. And I would refer to you anytime, because again, what you do is not state bound. And you guys have more, you've had boots on the ground in more situations than most people. So I'm grateful to you, and I'm grateful to you for the conversation. Thank you for the time today.
Oh my God, my pleasure. And thanks to divorce coach Jill, who
Yes.
got us together.
Yes, please. She's the bomb, and she does great work too online. And I'm in Fresh Starts. She's also in Fresh Starts, I believe, which is a great, great resource for people, low, no cost referrals. A lot of amazing women I'm meeting through that organization. So absolutely, it's a whole new world. There's a lot available online. Didn't used to be this way even 5-10 years ago. So
Yes.
really exciting time.
Well, Tracy, it's been an absolute pleasure. This is the first of many, I'm sure,
I hope
conversations.
so. I hope so.
All right.
Have a great day.
All right.
Bye to
You too.
Chris. Bye.
Bye.